Webinar. Good afternoon, everyone. Thank you all for being here.
Thank you for having me, Renata.
You're welcome. Thank you, Scott, for being here and sharing this good information. We're going to get started in a minute. We're going to let people come in the room.
Perfect.
Good afternoon, everyone. Thank you all for being here. We're going to go ahead and get started. I just wanted to briefly introduce our guest speaker, Scott Schweitzer. He is the managing partner of Promise State Planning. This is his second time here with PGCAR. His first webinar is posted on our YouTube page, so please go check that out as well. And this one will be posted as well as soon as by the end of this week. If you all have any questions, please use and utilize the Q&A and or the chat. We will be monitoring that throughout the webinar. And again, thank you all for being here. And we're going to go ahead and get started. Scott, you can go ahead and
All right.
the microphone.
Thank you, Renata. Thank you for the kind introduction, and I'm happy to be here with everyone today. So I'm going to share my presentation screen real quickly here. And there we go. We have it popped up here. And it was a pleasure giving a presentation last autumn too. So we chatted about, what people with the feedback from that presentation, and I wanted to focus in a little bit more specifically here on we talked about creating a revocable living trust, mainly for the purposes of avoiding probate. But the questions came up about how to actually fund that trust, or in other words, how to get assets into the trust so that your assets actually stay out of probate. So the first portion of the presentation is going to be a little bit of a refresher for those who were here before. For those who were not able to make it, it'll give you some context to what we're talking about today. And then we'll go into some case studies, and I will be asking people, to put a post in the chat as we go along. So please don't feel bashful. We like having your feedback. I'm going to ask some questions. We'll have a little bit of interactive time, and then at the end of the presentation, we'll have a formal Q&A, and we'll do that as long as we can and so forth. So without any further ado, for those of you who don't know me, my name is Scott Schweitzer. I am an estate planning attorney. I have a boutique firm here in DC, but we practice in DC, Maryland, and Virginia. And I grew up in Wisconsin, and I went to college in Chicago, moved out here about 22 years ago now. And been here ever since. Went to law school at Georgetown University, and immediately went into the real estate practice. I owned a title company with other attorneys and so forth, and did some estate planning, but really it was family events for me in 2017 that inspired me to focus in on the estate planning field. And really what it comes down to is my grandparents on my mother's side passed away in 2017, and I had a great aunt and uncle that passed away about the same time on the other side of the family, and they had sort of opposite experiences. Fortunately for my family, my grandparents had done a good job with their estate planning. They met with a specialty attorney up in Wisconsin. They brought my mom and her brother into the office to explain what was going to happen. They created a revocable living trust. They put assets into that trust to keep it out of probate court. And they shared all this information about their finances and their post-death plans while they were well. So when they passed away, there were no surprises. My mom and her brother went into the same attorney's office, and they basically administered the trust. It took about 3 months. There was no probate court. It was quick and easy and painless, and it allowed them to focus on grieving and family things, not on the logistics of having to go through a probate proceeding. And it was actually so collaborative that it brought the side of the family closer together because it was such a good process. So that's the one experience. On the other side of the family, unfortunately, great aunt and grand uncle were great, family members, great people, but they didn't like to talk about finances, and they didn't like to talk about death with their family. So I think their mindset was sort of that they would just let it, leave it up to the kids to clean things up when they passed away. So they did no planning at all. And when they passed away, their estate went through what's called intestate succession. And that is Wisconsin's plan, their rules for what happens to your asset if you don't make any assets, if you don't make any plans yourself. And not surprisingly, the kids didn't think that was fair. So they started fighting. They hired their own attorneys and they litigated the matter in court for about 3 years. And what was sad was that the actual value of the estate just about equaled the cost of the litigation. So nobody really got anything. And there are people on that side of the family that are still fighting to this day. And, I just know that if their, parents had foreseen, had known that this would be the outcome, they would have taken the time to get over their procrastination, get over their fear, and would have put a plan into place. So really that was the inspiration for me, just seeing that the alternatives in my family. And then I realized that at that point in time, I was working in a title company, my own title company, and I was helping a lot of people, who were buying and selling properties, who were downsizing, getting married, getting divorced. And if I could just educate them on how to own their property better, for legacy planning purposes, I would be doing a great service. So that inspired me to shift over to the estate planning portion of it. And that's where I've been focused ever since. So basically, I'm assuming that a lot of you here obviously are probably realtors. That would make sense. And so some of you are here to learn in this information so you can share it with your clients. Others might be actually taking this in for yourselves and your families. And for some of you, maybe a combination of the both. So as I go through the next few slides here, just post your reason for being here in the chat. And I'm going to take a look at that in just a couple of minutes. So the idea here of why did you come here today? It can be multiple reasons, but just, feel free to share. That'll help me kind of tailor this to your needs and make sure that you get what you need. Did you do this for your family? Did you make sure that they are in a situation where they know what's going on when something happens to you? Did you perhaps do it for peace of mind with regard to what happens to your assets or your client's assets when you pass away? Or perhaps were you thinking about taxes, tax implications, whether they're estate taxes, inheritance taxes, income capital gains? Are you really focused on your taxes instead? Finally, maybe you are thinking about who it is in your family, or your group of friends, in your world who would step forward to help out if you were either incapacitated or when you pass away. Who would be your people? Maybe you're looking around and thinking that, there aren't any obvious categories, and you're a little concerned that the default people who might be chosen to handle your affairs might not be the right people. But those are all concerns that people have as well. So I guess I'm going to stop the share a little bit here, and I'm going to actually look at this chat real quick. Actually, I can do this way. It's perfect. Okay, what am I seeing here? I'm seeing Chance Harris, myself, Martez Taylor, thank you both. Valerie, personal knowledge. Crystal, personal. Fred, both. Eugenia, both. Michael, planning for myself and family. Okay. How to fund the trust. Okay. Doing this for my family, and I have elder parents. Great. Getting a lot of responses here, which is perfect. So I'm seeing a lot of family. I'm seeing a lot of both. I see some people that have existing trust or existing estate planning, and they just want to make sure that they don't need to review their plan at all, revise their plan. I see some people here who actually acted as executor of their parents' account, but that really, taught them what the probate process was like. Yeah. Thank you. Thank you, Cynthia, for sharing that. I appreciate that. We have some questions about how much this service is and what it's based on. So I'm going to get into pricing and different options later on. Parents, and some people here who have a revocable trust, but it's not funded. Okay. Yeah, that's more common than you think. It's good that we've talked about funding. Fund or not to fund. Okay, perfect. And someone else is going through probate right now. Okay, perfect. I really appreciate all the feedback and everything. We'll get there. So what I'd like to talk about that actually is, so here, when was the last time you reviewed your existing plan? And so to the point of those of you who have trusts in place, but haven't actually gone through the funding process, that's more common than you would think. So basically, I have an anecdote here is that when before I was focused on trust and estate law and I had my title company, I had an unmarried couple come to me, and they wanted to create a revocable living trust and put the property in the trust so that if they, and put some special conditions, so that if they got divorced or never got married, they could sort of unwind the transaction without having to go to court to litigate. So it was short time notice, and what I said was, hey, we're going to close this purchase right now in your own personal names. You'll buy it in your own names, and then I'm going to refer you to a trust and estate specialist, and he'll create the trust for you. So we did that, and I made the referral. And then they came back to my office to refinance about a year and a half later. Rates are going down, just as they're hopefully about to go down right now. And I noticed that the house was still in their personal names. It should have been in the trust. And I said, huh, did you guys decide, not to put your property in the trust? Did you not work with the attorney? And they said, oh, no, we work with him. He was great. Thank you for the referral. That's awesome. And I said, okay, but again, the property is in your personal names, not in the trust. What was the point of that? And they said, this attorney created the trust, drafted it. We came in for a consultation. We came in for a second meeting to sign the documents, and it seemed like we were done. He really didn't talk about funding. He didn't talk about how to own assets, and he billed us by the hour. So we really had no incentive to go back and meet with him again, and we kind of just thought we were finished. So I had to inform them that actually what they had right now would be a failed plan if something happened to them. They had the documents in place, they had a trust, but their assets were scattered all over, still in their personal names. And I was kind of thinking that this would be malpractice on the attorney's part, but it's actually common practice. A lot of estate planning attorneys have a transactional approach where they have you sign the documents, and they either don't talk about funding or they mention it, but they just send you on your way, and there's no follow-up on their part. There's no accountability measures for actually getting the assets owned in the right way. So that's something that I went about changing when I started my practice. Is we actually built the practice to make sure that if you're creating a trust, that your assets get owned in the correct way. They actually get put into the trust. So to back up a little bit here, I mentioned this in my story about my grandparents and so forth. But if you don't create a trust, if you don't create a will, every state in the US and the NDC has a plan for you. It's called intestate succession, and it's based on rules that each state has differently on who they think should get your assets. Family members, spouses. It may not be the people that you actually want in those roles. I talk about a will a lot because, of course, I think the will is the most commonly mentioned or understood or misunderstood document in estate planning. Everybody's heard of a will before, and everyone kind of will contact me and say, hey, I need to create a will. And creating a will is definitely better than doing nothing. But a will is designed to go through the probate court process and be read by a judge so that the judge can decide who gets what. And the judge can decide which creditors to pay off before these assets go to your beneficiaries. So having a will-based plan, while it is better than not having a plan at all, it does not keep your estate out of the probate court process. And I think it's important for people to understand that, because a lot of times there's some misunderstanding. So I'm curious if any of you, some of you already mentioned this, but if you have stories about a probate proceeding, either one of your clients or someone in your family having to deal with a probate process, you can just, put a quick little blurb in the chat, and I'll get to that I'll get back to that at the Q&A session. Another important thing that just to be aware of for those of you who have kids or clients that have kids, a lot of times with will-based plans, and especially if there's no plan in place at all, beneficiaries receive assets at the age of 18. They receive them outright and unprotected. So there are no safety rails to make sure that the assets aren't spent all, at an early age, and to make sure that the newly young adults are protected from predators or people who would want to get access to those funds. And I like to also, you probably see this a lot as realtors, you see people who are trying to do-it-yourself estate planning. They're trying to avoid probate, or they're trying to pass assets on to their kids often, or to their spouse, but they're doing it in ways that have unintended consequences. So I like to share Helen's story real quick here. It's basically what happened here is one of my financial planners contacted me to try to help her client, Helen, who was trying to make sure her property in Tacoma Park didn't fall into probate court when she died. Unfortunately, she had already worked with a title attorney who suggested that she add her two daughters to title. The title attorney was trying to help, but he wasn't an expert in estate planning, and he didn't realize the downsides to this strategy. So I pulled the deed from the land records. Helen and her two daughters were now all owners of Helen's house. Unfortunately, the title attorney didn't specify the tenancy of the new owners in the deed. And some of you may know this, but when a deed is silent as to tenancy with multiple owners, the default tenancy is tenants in common. So since tenants in common doesn't have a right of survivorship, when Helen dies, her share of the property will not pass straight to her daughters. Instead, it'll go straight into probate court, which was exactly what Helen was trying to avoid. So mistake number one. Beyond that, one of Helen's daughters had recently gotten divorced and lost her job. So unbeknownst to Helen, she racked up a lot of credit card debt and couldn't keep up with the payments. So she defaulted on her debt, and because she owns 1/3 of the property, her credit debt went to collections, and the collection company recorded a lien against Helen's property. So Helen, of course, wanted to know how we could help her get rid of the lien since she paid off her mortgage and didn't have consumer debt. Unfortunately, she was stuck with this lien and had to decide whether to pay off the $75,000 of her daughter's debt, despite the fact that her daughter was over 40 years old. Mistake number two. Finally, my research showed that Helen bought her property in 1982 for $120,000. The property was now assessed at $1.2 million. One of the most valuable tax minimization strategies when it comes to real estate, and many of you know this, is using the step up in basis that occurs when your kids or other beneficiaries inherit your property. For example, if Helen decided to sell her property for $1.2 million, she would owe capital gains on the difference between the purchase price, $120,000, and the sales price, $1.2 million. Because it's her primary residence, the current law would exempt some of this from tax, but she'd still have a sizable bill. However, if she retained ownership of the property until her daughters inherited it, they would get a new basis of $1.2 million. And what this means is that if they turn around and sold it for $1.2 million after she passed away, there would be no income tax, no capital gains tax owed. That's a huge savings. So it's really important to families that want to minimize intergenerational taxes to realize that. But in Helen's case, by gifting 2/3 of the property to her daughters, they inherit her original basis and will now have to pay the capital gains tax when they sell the property. So Helen wanted to know if I could help her fix this, since nobody advised her of the tax consequences of the gift. Unfortunately, once you gift the property, you lose this tax benefit forever. So I felt bad for Helen. We helped her out as best as we could, but there were certain mistakes that she was making there. And this just can also be sort of something that a red flag when you see clients adding their kids to title of the property. That's usually a sign, typically, that they need the help of this estate planning practitioner. You know what I mean? And they're trying to do things themselves that may not be in their best interest. Okay, so I alluded to this before and talked about it in the context of my grandparents and so forth. So the best way, or one of the best ways to get out of probate court, or to avoid going to probate court, is create the revocable living trust, which here looks like a suitcase. There are lots of kinds of trusts out there. There are a variety of irrevocable or irrevocable trusts that are more complex, that have tax consequences. They can be created for estate tax purposes, avoiding estate tax. They can be created for Medicaid asset protection. If you have clients who have loved ones who are getting assisted living or in nursing homes. There are special needs trusts if you have family members with special needs. There are charitable trusts. There's a whole variety of things, but I'm focusing in on the most standard, straightforward trust, which is the revocable living trust. It has no tax consequences. It's a pass-through entity. And its main purpose is to organize your assets, keep them out of probate court, and it also has some benefits in case of incapacity. So we see here different types of assets, and then going inside of this revocable living trust. So basically, I wanted to split assets into two categories here. we have assets, and I always tell my clients that tend to go through probate. That would be your cash, your real estate that's owned solely by yourself in your own name, stocks and bonds, businesses and personal property. These assets, with or without a will typically go through probate court. On the other hand, if you have beneficiary designated accounts like life insurance or retirement accounts, they typically do not go through probate. However, exceptions to this would be if your beneficiaries are under the age of 18, like if you put minor kids as beneficiaries of either of these accounts and you pass away when they're under the age of 18, those funds will go through probate for a judge to appoint a conservator to manage the funds on the kid's behalf. So that's one big practitioner point. Do not leave these types of accounts directly to minor kids, because you're ensuring that the assets will go through probate and that perhaps some random person will be put in charge of the funds. Also, I have a lot of clients who have out-of-date beneficiary designations. They may be leaving it to family members that have passed away, parents. They may be leaving it to ex-spouses. So you want to make sure not to do that either. So basically, how do we deal with probate assets? So things like cash, real estate, stocks and bonds, businesses. What we don't want, there are basically a few ways of dealing with it, but basically the first option is to retitle those assets from your personal name into the name of the trust. And I always talk about this with my clients as we go through an asset spreadsheet that we've created with them. That's the first option, retitle it into the name of the trust. If your bank or financial institution wouldn't allow you to do that, you can add a payable on death beneficiary to the account. That will have largely the same effect. It just comes down to the bank, what the rules are. And finally, some banks and financial institutions are really stubborn, and they will require that you open a new account and transfer the money from one to the other. That's our least favorite option, but it is an option if the other two don't work. In terms of beneficiary assets, we're talking about life insurance or retirement accounts. You actually don't move those accounts into the trust. You leave them in your own name, but you update the beneficiaries in a way that the trust plays a role. For life insurance, typically you actually name the trust as your primary beneficiary of the life insurance. So when you pass away, those assets pour right into the trust. When it comes down to retirement accounts, there are a couple of options. For income tax reasons, it's often beneficial to leave, as a primary beneficiary, leave those assets to the surviving spouse. For those of you who know about the PGCAR Act or have other people who deal with finances, you've maybe heard that IRAs and things like that can be stretched out. What that means is that certain types of people, like a surviving spouse, can delay taking required minimum distributions over a long period of time. So you have income tax benefits for leaving those assets directly to the surviving spouse. You would then add the trust in as the backup or the contingent beneficiary. Some of this comes down to whether or not that makes sense for your situation, though. Sometimes we want asset protection. Sometimes we don't want our beneficiaries to inherit the assets, even retirement account assets directly. And if that's important to you and your clients, we can plan around that as well. So, more about asset protection. One of the things I often tell my clients is that we'll take a look at what happens. Let's say you have a couple with minor kids. You'll take a look at what happens when one of the couple passes away. And you'll take a look at what happens when both mom and dad pass away. And if you have minor kids, a lot of times you don't want those kids to inherit those assets outright. And one of the solutions that you can choose is you can create a trust. I call it a lifetime asset protection trust. And the assets go into the trust. They're divided up into shares for each kid. This can be for grandkids as well. And you nominate an independent trustee who manages those assets on behalf of the kids. This has a variety of potentially beneficial outcomes. One, the kids don't waste the money at a young age. Two, those assets are in an irrevocable trust, so they have credit protection. So if your kids, your grandkids ever have a creditor come after them, ever have to go through bankruptcy, those assets are protected. If your kids get married to someone else and then get divorced, those assets are not going to be considered marital assets, so they're protected from ex-spouses as well. And then also, if your kids do well financially, and they would otherwise have estate tax issues when they get to be older, these assets are not considered part of their estate, so they're not going to be taxed when your kids pass away. So it's just a good tool I like to share with people a little bit. Let's see here real quick. Okay. We're coming up on time. It's actually been 25 minutes here. So I'm just going to go real quickly through my process. Basically, how I work with clients is I meet with them for a 2-hour intensive meeting that I call a family wealth planning session. I charge 2 hours of my time, which is $750. But what I do is I give my prospective clients a way to get that meeting at a discount of $250. And that is I send them some homework, a questionnaire, and that questionnaire helps them get really organized financially because it asks them to list out all their assets and so forth. So it's helpful for them, it's helpful for the family. And if they do that in advance of the meeting, they get the family wealth planning session for $250. Once we get into the family wealth planning session, that $250 is credited towards any planning that they actually decide to do. And our average fees range between $2,000 and $8,000. It's a big range. Our average cost is about $4,500. So it's not cheap. We're pretty expensive, but we do a really good comprehensive job. It's just something that if people want to work with me and so forth, then just kind of like to share the fees so people are aware of that. I get some clients who really want to work with us and they want to go through our process, but they don't have that kind of cash on hand, and that's fine. I just tell them to if they really want to do that, they can wait and save up the money and then let us know when they budget it for them. On the other hand, some people, they want to do some estate planning, but you probably don't need to actually come in with us. And that would be if your situation is really simple. If you know exactly who you want to get your money, if you think there's very little chance that any of your assets would go through probate, if you have less than $60,000 in real estate, stocks and bonds, cash, and things like that, your estate would go through a quick and easy expedited probate course, and you wouldn't need to come and create a trust for the most part. So what I want to do also is I gave to Renata basically here it is right here, a presentation that I did back in January on do-it-yourself estate planning. So she's going to be circulating that as well. So for those of you or have clients who want to do estate planning, but they're not ready to work with us, they're not really ready for a family wealth planning session, that's going to be an opportunity for them to put some of those documents in place without having to hire anybody. And it's certainly better than nothing. So, all right, we've gotten to the Q&A here. So this QR code, we all know our QR codes. You can go to your photos and your phone and you can scan it. If you want to schedule a 15-minute call with myself and my team to talk about estate planning, potentially talking about, giving a presentation to maybe people in your office, some of your clients, whatever it is, this is your opportunity to go ahead and schedule a 15-minute call with me. So I'll leave it up there for a little bit now. And basically what I'm gonna do is open up to a Q&A. So let's just see here real quick. This over here.
There's a question in the chat, Scott.
Is there? Okay,
It's
perfect.
Ms. Hurd asks, does a home have to be paid off to be added to the revocable trust?
That's a good question. And the answer, thankfully, is no. It does not have to be paid off. The majority of our clients have homes with mortgages that are added to the revocable living trust. And because the revocable living trust is a pass-through entity, putting your assets in there does not trigger the due on sale clause of your lender. So you can certainly let your lender know that it's being put in a revocable living trust, and you can ask them for guidance or permission, but it does not have to be paid off beforehand, which is great because most people, actually don't have paid off their homes right away. Okay, so using a phone to view the presentation, how do we scan the QR code? So basically, if you see the QR code, so over here, you would just go to the photos section. You would point the camera at the phone or at
Now,
the
the question is, if she's using her phone to view the presentation, how can she get access to schedule for you?
Yes. So you just point your phone out there with the camera, and there will be a little box that pops up. And what you'll see is a schedule online option here from our webpage, and you can scroll down and you can click on the box that says click here to schedule. And that's going to bring you to my scheduling page. And you're going to see options here for either a consultation, an estate planning consultation, or a non-estate planning consultation with me. You also see some options for my team members, but you can focus on me for right now.
Okay, do you have a link to schedule if they're using their mobile device they can't point while they're using their phone? So
Sure.
can you share the link to schedule as well?
Yeah, let me go ahead. I'll share that
Okay.
right now. Happy to.
And while you're doing that, there's another question.
Okay.
Do you provide a complimentary relook after someone else's procures your service?
So I'll put it in two ways. If you have existing estate documents, here's the chat here. Okay, I just posted the link to the 15-minute call with me in the chat there. If you have existing estate plan, plan with from another attorney or something you did by yourself, you have sort of two options when it comes to working with us. If you think it's out of date, or if you think that it's something that's really very preliminary, we can basically just use it to reference, and we'll do a brand new plan. You know what I mean? But I'll look at it to make sure that they're consistent and we don't forget anything. If, on the other hand, you spend a good deal of money, work with another attorney, created a trust-based plan, and then that attorney retired, or your relationship kind of fell by the wayside, I do offer a full estate plan review service where I go through a big document. I spend a few hours and actually do a full comprehensive review of the trust and everything else. But that is a flat fee of $995. So that's actually more expensive than just starting from scratch. And that's just simply because it takes more time. Let's see here.
Okay.
Anyone else? Any other questions at all?
If an estate has been closed out and something comes up later where the deceased person's name is on a loan, what is the next step for the executor?
Well, what happens at that point in time is you'd have to go back to whoever it is, whatever attorney that you work with, to handle either the probate or the estate administration procedure. And you determine whether there's a way to get around that without having to reopen the estate, or if you actually have to open the estate again. I work with a colleague of mine who handles trust and estate administration and probate, and he regularly handles those matters. So if you have a specific question, or if you have a specific matter that you need help with, I can pass his information along too.
Awesome, thank you. Let's check the Q&A. To keep the property in the family, is it best to retitle into the name of the trust while you're alive?
Absolutely.
Upon
Yes.
death, the property transfer into the family trust.
Yeah, so what you would typically do is, while you're alive and well, you create the Revocable Living Trust, and you would then transfer that property into the trust while you're there. And there would be certain instructions in the trust of what happens on your death, and that would keep the property out of probate. That's exactly right.
Okay, awesome. I was just sharing the link. Let's see.
Thank you.
You're welcome. If a parent owned property in another state and died without a will or officially transferring the property, what would be the best way to start the process to get the issue resolved? Should they get an attorney in Maryland where they live, or in Alabama where the property?
Well, the short answer might be both. So if you are somebody who lives, let's say, in Maryland or DC, and you have assets also in Maryland or DC, let's say you have bank accounts or retirement accounts, investment accounts, etc., or real estate, and if you have a property in a different state or even a different country, it's really important that you have a trust in place so that you can put all of your properties into the trust. Because what happens is, if you don't, and you pass away, and you have properties in different states, what has to happen is the separate probate proceeding has to be opened up in each state, in each country where you have those assets. Think businesses, think real estate. So if you're a real estate investor and you have, let's say, primary residence in Maryland, and you have investment properties in DC, Virginia, and on the West Coast, and you don't have a trust-based plan, and your properties aren't in the trust, your kids, your family is going to have to go ahead and hire attorneys in every single one of those states and go through a probate process in every one of those states. And so those can be some of the most lengthy and expensive and complicated. probate proceedings. So for those of you who are real estate investors who have vacation properties, this is especially important for you.
All right, thanks. Should all of my investment properties be in separate LLCs or in one LLC when adding it to a trust?
Well, that's a good question. I think that comes down to how risk adverse you are and how much you're willing to spend money on the extra paperwork that comes having different separate LLCs. And I have investor clients that do a range of things. Some of them, for example, some of them will flip properties and they'll have a separate LLC for their flipping business. And then they'll have one other LLC that holds their rental properties. And that can work for some people. Other clients are more risk adverse. They don't want the possibility of a lawsuit from one property infecting and going over to the others. So they will set up separate LLCs for each rental property. It just depends. It's kind of a business decision, actually. When it comes to LLCs, investment properties, and the trust, it doesn't really matter, actually. We can work with it either way. What we do is we take your membership interest in the LLC or LLCs and we assign it to the trust. So that has the effect of wrapping the trust around the LLC to keep those businesses, those properties out of probate court. And it's actually easier when your properties are in LLCs than it is if they're all in your own name. Because if they're all in your own name, we're going to have to do a separate deed for each property recorded in the land records. But if you have just LLCs, we can assign your membership interest to the LLCs to the trust through a private document that doesn't involve the land records.
Okay. If the house is in a trust, do I lose the ability to claim tax benefits?
So if it's in the trust and it's your primary residence, you can still get homestead benefits. You can still get all the tax benefits that you would otherwise get. And that's true in Maryland, DC, and Virginia. I'm not sure about everywhere else in the country, but broadly speaking, that's the case. The one exception I know is not Maryland, it's in DC. And that is, for whatever reason, in DC, if you have a property in a revocable living trust, DC can subjects it to rent control. Whereas if it was in your personal name and you only had a couple of them, it could be exempt from rent control. Why do they do that? I'm not sure. It doesn't make any sense to me, but it's unfortunately one of the consequences in DC.
Okay. Can you explain what does funding the trust mean?
Sure. Funding it just makes sure that you're getting the assets into it. So in the context of things that would go through probate, like cash, stocks and bonds, real estate and business, that means changing the title of the accounts to from your personal name to the actual name of the trust. When it comes to accounts like life insurance and retirement accounts, that means changing the beneficiary designations to include the trust so that when you pass away, the assets go into the trust rather than somewhere else.
Okay, so there's two questions. Well, two people are asking the same question. What's the difference between a revocable and irrevocable trust?
So a revocable trust is the one that I've been talking about the whole time. It's the most flexible estate planning tool, meaning that it's revocable. You can set it up, put things in there, you can amend it, you can restate it, you can revoke it, you can change it, it can go away. There's no limitations on what you can do with it. You don't lose any control of your assets. Irrevocable trusts, you are giving up control for some sort of other benefit. You're getting those assets away from you. You're putting someone else in control. So you don't get to call the shots. You have to get a committee of people, including the trustee and perhaps all the beneficiaries, to make changes. So that's the big trade-off when you're doing more advanced estate planning using irrevocable trusts, is you are losing some control.
Good to know.
Yeah.
What what are the tax implications for the revocable trust? Do I file for individual and the trust?
So because it's a pass-through entity, you can use your personal security, social security number when you file for the taxes. If you have a joint trust with your spouse, you can just choose one of the social security numbers and file jointly. So it's a good question. The answer is you don't have to create a separate tax identification number for a revocable living trust. Once you pass away and your trust becomes irrevocable because you died, then your trustees will have to, in all likelihood, file a separate number, but they'll be working with the CPA and your attorney to administer your estate. So that won't be that difficult for them.
Okay. What's the best way to hold a rental property in an LLC that is owned by the trust?
Well, if you're going to hold it in an LLC, and then you just do what I talked about before, is you assign the membership interest of the LLC to the trust and you're done. And that's something that we often will just do for our clients who want like a turnkey experience. So we have some clients who like to self-fund. We give them instructions and we hold them accountable. We have other clients who just want to pay us to get the funding, the transferring of title and so forth finished. And then we handle everything for them. Just depends on their budget and how much time they have.
Okay. Another question in the Q&A. One of my clients, he lives in Virginia, contacted me on Sunday and wanted to know if he would have a problem selling his 85-year-old ill father's home if he passed away. The property is in Maryland, no mortgage. Apparently, he has a relative that is running into problems selling her deceased husband's property in California, and she lives in Texas.
So just real quick, I may have missed something. Was the property held in the in the elderly person's name, or was it held in a trust name?
I would have to, let's see if I can request her to speak,
Okay.
if she's still here. Ms. Williams, can you elaborate on your question?
Yes, it's being held in the father's name only.
Okay. And does he have capacity? Is he able to sign off on a contract and to attend settlement?
No, no, I actually sold one of their properties a couple of months ago, which was a commercial property, and the son had a power of attorney to do handle the transaction for him.
Okay. And for this new property, is the son also power of attorney?
I believe so, yes.
Okay. That is, I mean, that's, in the situation, if you own properties in your own name and you become incapacitated, a specific power of attorney for the state, wherever the property is located, is usually the way you have to go. And typically a title company can help you with that and give you the kind of guidance that you need. It's not always easy. Powers of attorney are really viewed as in that situation, are viewed as potentially risks for fraud and so forth and lawsuits. But yes, with the correct power of attorney, if it's owned in your own name, you should be able to get that set up. The question is, does the owner right now, does he have the ability, if there is no power of attorney, and he didn't have capacity, he could not now give someone else power of attorney. So what happens sometimes in those cases is that, clients who become incapacitated and don't have powers of attorney will have to, basically, those properties will be frozen for a period of time until the client either regains capacity, so they can do something, or until they pass away, unfortunately. And that actually is, one of the benefits of having the property in a trust is you and your spouse will be the trustee, but you'll name backup or successor trustees. So if you become incapacitated at any given time, all your successor trustees can simply nominate themselves and step into their role, and they can just then sign on behalf of the trust. And so you don't have to worry about gathering powers of attorney as time goes by.
I think I'll just refer him to you.
Okay, we'll see if I can help.
Okay, we have more questions. So I want to make a loan against the home HELOC.
Okay.
Do I have to take the house out of the trust, then put it back in?
That would depend on what the lender's requirements are. Most lenders these days, if you're getting a primary mortgage, they're okay with the property being held in a revocable living trust. It might be a little more challenging with a HELOC specifically, but all you'd have to do is ask them. Hopefully no, but if they do, you can have your title attorney easily just draft a deed to move the property out of the trust, get the HELOC, and then move it back in. It's just a zero consideration transfer. There's the recording fees, but there's not any sort of transfer tax associated with that.
Okay. What, if any, benefits are there to having an irrevocable trust?
So that's a complex question. Irrevocable trusts are used in a variety of advanced estate planning situations. They can be used if you have a very large estate. but think like over $10 million, and you're going to be subject to estate taxes. They can be used to move certain assets out of your estate to minimize those taxes. They can be used if you have a business that you're trying to sell to the next generation. There can be some tax efficient ways of planning that use irrevocable trusts. They can be used if you are charitably inclined. You can set up charitable trusts with great tax implications, both for your kids, yourself, and the charity to make that work better. You can also use it, for example, if you have kids with special needs, or if you have a spouse who is going into nursing home, has a diagnosis like Alzheimer's, and you are trying to avoid having to spend down all of their assets to qualify for Medicaid. So those are just a few of the potential benefits of that kind of planning.
Wow, that's really good to know. What are ways to still financing equity loans, refinance, and get the benefit of a revocable funded trust?
So similar to what I talked about before, most lenders these days are going to be comfortable giving you a loan with the property in a revocable living trust. So it should not be a big deal.
Okay, let's see. Can you place heirs property in a trust?
Can you place heirs property in a trust?
Yeah.
Potentially, if you have an open estate and you have the authority to move their assets around, you might be able to place into a trust, but typically not. If they have a trust that's been created already, you might be able to make a motion with the court to move it into the trust, depending on which court you're in. But if you haven't created a trust, and the property's in probate, and the will, if there is a will, doesn't dictate that the property goes into a trust, you can't just create a trust yourself. You're just going to have to go through the probate proceeding. And so that's why, of course, we want to create those trusts before the grantor passes away.
Okay. And our last question says, how's the trust funded?
So kind of, I think I covered this a couple of times before. So it's either a title change for certain types of assets, or it's going to be a beneficiary designation change on things like life insurance or retirement accounts.
Okay. That is the conclusion. That no one else has any questions. Again, Scott, thank you for
Sure.
being here and sharing all your great knowledge with our membership, Prince George's County Association membership. And you all please schedule if you have more questions, or if you needed to have an extended conversation about something you're going through, please scan the QR code. I'm going to try to find the link, his schedule link, if you cannot scan the QR code. Let me place that in the chat to everyone. There is a survey that's going to pop up at the conclusion of this webinar. Please take a minute to give us feedback. Let us know how Scott did, of course, and what other webinar topics you would like to see in the future. Otherwise, thank you again for attending today's webinar. Scott, thank you again. If you have any last things to say, please feel free. Otherwise, you all are free to enjoy the rest of your afternoon.
Thank you, Renata, and thank you, everybody, for participating today. I hope it was helpful. Renata's going to pass along a couple presentations that I think will be good additional resources for all of you. And if you have additional questions, I look forward to chatting with you. All right, take care.
All right, I did place those documents in the chat. If you did not get them, just send me a quick email. Again, thank you, Scott. Bye, everyone. Have a good afternoon.
Thank you.